Sorry, it's never quite when we say it'll be, but it'll do badly. Can I just mention one thing? I think some thought needs to be given as to who to deal with what points in reply. Normally an intervener doesn't have any right of reply. Given the way this hearing has panned out, I think it would make sense for Ms. Savage and Mr. Metzer to consider whether there are any points that they would like Mr. de la Mare to deal with. We may be a little bit difficult to do that while we're all sitting here, but can they at least be thinking about it? If necessary, we'll have 2 minutes at 4 o'clock and see. Very well.
Thank you. Can I again, coming back early? We are still in the directive. Tab 2. I've taken the court Article 9. Briefly, just to note Article 15.1. The procedures provided for by Articles 30 and 31 should apply by analogy to all decisions restricting free movement. That provision applies in principle to extended family members. I'll take the court to the Danger case in a moment, but it doesn't confer the full suite of procedural rights in Article 31. For the court to note, I'm not going to take the court to an authority on this because nothing turns on it, but Nicola has submitted that Articles 27 and 28 apply when a decision is being made about an extended family member. We say they don't, and we've dealt with that in the footnote to our response, footnote 6 to our response to the intervener. And then finally, as I'll be taking the court to Danger, can I just ask the court to look at Article 31, page 121?
Yep.
So it does two things. It prescribes for availability of the redress procedure, and then it prescribes the content of that procedure. Article 31.1 says the persons concerned should have access to judicial and where appropriate administrative redress procedures. So that's availability of the procedure in principle. And then what's the content of the redress procedure? See Article 31.3. The redress procedure should allow for an examination of the legality of the decision, as well as the facts and circumstances on which the proposed measure is based. They should ensure that the decision is not disproportionate, particularly in view of the requirements laid down in Article 28. Now, I'll take the court to Danger, but we say that does not apply to extended family members because of the bespoke nature of their rights. So the third topic that I was going to cover was the 2016 regulations. I know that the court spent some time on them already, so I will take this as quickly as I can. Regulation 7, page 325 of the Authority Bundle. Just to reiterate, and Ms. de la Mare fairly said this, Regulation 7.3, you have to be, not just be an extended family member, in other words, that's the definition, but you have to have been issued with an EEA family permit or one of those other documents. And you need to continue to satisfy the conditions, so it's not enough to have the document. If, for example, you don't continue to be dependent, the fact that you've got a document doesn't help you because of 3A, and the EEA family permit, registration certificate or residence card remains in force. And we say that reflects what the court saw on the family permit that was handed up, the valid until date. Once the validity ends, it's no longer in force. So that's important because we say unless somebody has actually been issued with an EEA family permit, they are not a family member and they cannot be admitted under Regulation 11. So just asking the court to turn up Regulation 11. Regulation 11.2 is family members. So somebody with an EEA family permit can come in under Regulation 11.2. Regulation 11.3 deals with the stamp. Now, as I've said, the stamp is not redundant because, contrary to what Mr. Delamere said, Regulation 11.4b allows, and indeed it would be required as a matter of EU law, that a person who turns up as a direct family member at the border is allowed to enter if they can show that they are a family member with a right to accompany that EEA national or join that EEA national. So that's the provision which says if you are a direct family member, you don't need to obtain one of these documents, and it's in that situation that the stamp would be used. An extended family member can't take the benefit of that because they can't be a family member without the issued family permit. So that's Regulation 11.4b. The upshot of that is that there is no basis for admitting somebody who doesn't fulfil one of these criteria. They do not have any right of admission under the 2016 regulations. The only people who have rights of admission under the 2016 regulations are those who are provided for in Regulation 11. And neither of these appellants are provided for in Regulation 11 for the reasons I've just given. Now, taking then, going back to, and I'm mindful that the board's aware of it, going back to keeping a finger in the regulations, but going back to tab 4, which is section 7 of the 1988 Act, what is the correct position in law if a third country national turns up and they don't have a right under these regulations to be admitted? The answer is that they require leave to enter or remain under the 1971 Act, and the reason for that is because they won't have an enforceable EU right, and they also won't have any right under the 2016 regulations, which is provision made under Section 2.2 of the European Communities Act. So that is why the immigration officer, we know that these individuals didn't have an enforceable EU right in terms of an absolute EU right to enter because they're wanting to be extended family members. We've looked at Regulation 11. They did not have a right to be admitted under the 2016 regulations, and so they were like any other third country national. They needed leave to enter or remain. So what the immigration officer needed to do was either turn them back or, and this would be very unusual, grant some kind of exceptional leave outside the rules. What the immigration officer couldn't do was say, okay, I'm going to let you through. And as we said broadly, that could only have been done if there were a mistake as to the facts, or a mistake as to the law, or a decision to not bother with the law. Broadly, those are the umbrella headings, but there was certainly no basis for admitting these appellants under these regulations. They required leave to enter or remain. So going then back into the regulations, Regulation 12 are the rules on issues of family permits, and they're issued not by immigration officers, but by entry clearance officers. So the provision that bites here is Regulation 12.4 of 5. I know the court's seen it, but just to make sure that there's a discretion to issue a family permit to an extended family member if the EEA national meets the condition in 12.1. The extended family member wants to accompany the relevant EEA national to the UK or to join that EEA national, and in all the circumstances it appears to the entry clearance officer to issue the family permit. So if the entry clearance officer has not considered whether or not it's appropriate to issue the EEA family permit, there's also in Regulation 12.5 a requirement for an extensive examination of the personal circumstances of the applicant to be undertaken by the Secretary of State and for reasons. And then 5A, issued in electronic form, and 6, issued free of charge and as soon as possible. That's different for a residence card, you have to pay for one of those, but the EEA family permit is free. Now, why then does the Secretary of State not accept applications for extended family members at the border? Because it's just not practically possible to go through all of the things that need to be gone through at the border, because what you need to do first of all is determine a factual state of affairs, which is, are they meeting the conditions themselves? So, for example, were they dependent in the host state? Are they dependent now? Because that's one of the requirements. What is their EU national family member doing? And is it in all the circumstances appropriate to issue the card? And that requires, it isn't a dead cert, because it requires consideration of things like how integrated is the EU national in the member state? Will there be an effect on their exercise of free movement rights if you don't exercise the card? Does the applicant have any kind of adverse immigration history? So it can't be done at the border, which is why the UK system provides that you need to make this application, otherwise you can't be admitted. And that's a point that's picked up by the Upper Tribunal in Underhill at paragraph 37. I don't need the court to turn it up, but the court may want to turn it up, but it effectively reflects what I've just said. That's why. It's also why the Secretary of State requires the application to be made on a prescribed form. So that's Regulation 21. It has to be, this is page 343, an application has to be made online, submitted electronically using the relevant pages or by post or in person. That's because the Secretary of State designed a form designed to elicit all of this information that would enable him to consider whether the conditions were met and whether the discretion should be exercised. And that is why Regulation 21.4 says if an application isn't submitted in accordance with those requirements, it's invalid and must be rejected. For completeness, just Regulation 21.3 makes clear that if you want a residence card, you have to be in the UK. That's Regulation 21.3. The only other thing I should have mentioned is you can't grant an EEA family permit to somebody who is here because you have to be accompanying to the UK or joining. So what it is, it's to get you into the UK so that you can make whatever application you want to make. And for an extended family member, that will be the residence card application, because you can't make that from out of the country. So there's provision in the rules for your admission to be facilitated so that you can then come and make the substantive application you need to make for residence, which is the application for a residence card, which has to be made here. And the idea is that you've got a 6-month period, which is enough time to come and to make your application, which is why the validity is 6 months of the EEA family permit. And then just a final point on these regulations is to mention that they, and I think this point has been made, that they deal separately, Regulation 11, with the right of admission to various provisions on right of residence. So for the purpose of the right of residence provisions, to be a family member, you also need an EEA family permit. And just to clear something up, what you can't do if you're an extended family member is say, well, Italy allowed me to be a family member.
Sorry, I didn't hear.
What I can't do as an extended family member is get myself facilitated in Italy and then rely on that as against the UK. And that's where the Upper Tribunal's gone wrong. And it's why when the Upper Tribunal in, I think it's Hasanaj, says there was a 3-month residence period on account of a residence card, there wasn't.
Well, the tribunal didn't say that.
The tribunal
You
said,
did.
yes, I know, and it's wrong, yes. The tribunal doesn't pick it up, but it's our respondent's notice point is, no, that's wrong, there isn't. You can't. The reason, as a matter of fundamental principle, is because Italy has got different criteria from the UK on when an extended family member is going to be able to have a right to reside. So Italy might say, we're happy to take anybody who does Y. The UK's conditions are Z. So what a person can't do is rely on the fact of facilitation in state 1, in state 2, and that follows inexorably from the fact that the conditions and the process are for national legislation. So that's just to clear that up why the Upper Tribunal went wrong in Hasanaj, in Vasa. So if you turn up at the border and you have an EEA, if you turn up at the border with you want to be an extended family member and you've been facilitated in Italy, you still don't have the right permission. So just to briefly show the court guidance, which is at the back of Authority Fundament 2, I won't take long on this, but it just puts a bit of colour on it. Tab 45, this is guidance for ECO, entry clearance officers. So page 1464, it sets out what is an EEA family permit, and it explains that it's valid for 6 months, and you've seen that on the document, and you can even enter multiple times within that period, and then it just reflects Regulation 73. And then it says extended family members must apply for a residence card if they want to stay in the UK after the person's expired. That just follows as a matter of law, because once it's expired, you're not a family member anymore. And then just to be clear, although it uses the entry clearance format, as a matter of law, it's not entry clearance. It's because entry clearance is converted into leave to enter at the border, and that's a separate system. And then just at tab 46, so that the court can see, this is guidance on extended family members, and just to flesh out how it works. 1483, we sidelined. It just explains that the application needs to be made online and so on. And then just in terms of showing what I said about what sort of things are taken into account at the discretion stage, page 1501. So the effect the decision has on free movement rights, and then another example at the bottom of 1502, integration of the applicant into the UK, and next page, integration of the sponsor into the UK, and also family and private law.
Who read that?
Bottom of page 1502, top of page 1502. So these things require evidence and they require consideration. So what I want to do now is just draw out 2 points by reference to case law. The first point is to answer the question, what is the EU law founding? what you need to do is make an application under the 2016 regulations. Now, the reason that I'm doing that is because the question that Article 10.2 asks is, have you been facilitated in accordance with national legislation? The question that Mr. Delamere poses is, well, have you made an application? We say the answer to both of those questions is no. So starting first with Rahman, and I'm mindful that the court is very familiar with this, tab 23, page 824. The just, first of all, the dispositive on page 824. On questions 1 and 2. So this is what is this right? And this sets out effectively what the EU law controls are. So the paragraph 18 onwards answering the question, paragraph 26 summarises it. So what are the EU law requirements on member states? The first indent, they're not required to grant every application for entry or residence, we know that. 2, it is, however, incumbent upon the member states to ensure that the legislation contains criteria which enable those persons to obtain a decision on their application for entry and residence that is founded on an extensive examination of their personal circumstances. Now, we say that the UK has done that, and that was a submission accepted in Sadiqa because it set up a system for 2016 regulations to be made. Indeed, it's done so by designing a form which elicits the relevant information. So it's legislation, and legislation does contain criteria which enables persons to obtain a decision on their application for entry and residence. The difficulty for these appellants is the legislation was there, and indeed the guidance was there, but they didn't apply for an EEA family permit. I accept that's not dealing with the point about the stamp, but in terms of what the UK's obligations were, there it was, the ability to apply. And then the member states have a wide discretion when selecting those criteria. So when the member state is deciding what conditions it wants to apply, it's got a wide discretion, but the criteria must be consistent with the normal meaning of the word facilitate and of the word relating to dependence, and must not deprive that provision of its effectiveness. And finally, every applicant is entitled to a judicial review of whether the national legislation and its application satisfy those conditions. Now, no mention of proportionality there. There's a mention of not depriving the provisions of their effectiveness. And the court may be aware that that's usually what's used for things like procedural safeguards, which are for the member state to design. So that does not bring in the proportionality standard. And then, question 5, this was a question, starting on page 825, this was a question about, well, Article 3.2a says that you need to be dependent in the home state, so before you come to the new state. Can the member states set requirements as to the nature and duration of dependence in order in particular to satisfy themselves that the situation of dependence is genuine and stable? And the court says, yes, but again, not that those requirements must be proportionate, but those requirements must be consistent with the normal meaning of the words relating to the dependence referred to in Article 3.2a and do not deprive that provision of its effectiveness. Now, paragraph 38, the court refers to the Advocate General at paragraph 105. Could I just invite the court to turn to the Advocate General's opinion at page 816? Because the Advocate General says a couple of things. Paragraph 104 and 105, the Advocate General says you can lay down particular conditions for obtaining the right of entry and residence in order to ensure the reality, effectiveness and duration of the dependency. then goes on to say, such conditions must, however, respect the principle of effectiveness, which the court itself says in paragraph 39 of its judgment, and then gives the example of, well, what you can't do is say you can only come if you've been dependent in person for 20 years. The Advocate General then goes on to say, also, the conditions must pursue a legitimate objective, be appropriate for securing the attainment of that objective, and must not go beyond what is necessary to attain it, which is, of course, the proportionality principle. Not picked up by the court. All that the court says, and this is why we say there isn't a proportionality requirement, this is the case where the ECJ says, yeah, this is what this right gets you. And it's very limited. It's, has the member state done something to deprive Article 3.2 of its effectiveness? And we say no in this case. We've got a system. There's nothing that we've done that's deprived Article 3.2 of its effectiveness. Just finally, that final question looks at, well, what about, can the member state also set rules for what the dependent family member needs to be doing in the host state? So that would be, for example, requiring them to be dependent in the host state, and the court's completely hands off with that one. It says at paragraph 45, well, paragraph 44, well, that's not dealt with in the directive. The legislature didn't settle either in that provision or in other provisions the question whether family members, can be refused a residence card on the ground that they cease to be dependents. So the directive doesn't deal with it, so it doesn't fall within the scope of the directive. In other words, that is purely a matter for national law. So what the court is, I hope, seeing is my submission that A, there isn't a proportionality principle, B, this is very much hands-off. Now, we would say that procedural requirements, analogously to question 6, are fully a matter for national law. But to the extent that they're not, then the analysis in question 5 applies, and the test is there deprivation of Article 3.2 of its effectiveness? So that's a substantive right. What is the procedural right? Banger or Banner, I'm never quite sure, is at tab 25. Banger.
Banja.
That's, yeah, I've always been getting that wrong.
Well, I've been saying banger for 30 years, so very well to do one.
This was a reference from our tribunal, and one of the questions is framed at paragraph 42. And the question, just captured in the 2 lines above paragraph 43, is, does Directive 2004/38 require a redress procedure whereby matters of both fact and law may be reviewed by a court? Now, the court may recall that's what Article 31.3 says. So then the court does what it does, which is tell everybody that it's got a better way of framing the question. That's in paragraph 43. And then the court says at paragraph 44 to 46, I think it is, that essentially Article 15 applies. So the procedures provided for by Articles 30 and 31 are to apply by analogy. And although it says those provisions don't expressly mention extended family members, in fact, some provisions, when they talk about family members, also must mean extended family members, and this is one of them. And then the court at paragraph 47 and 48 says that there must be an effective judicial remedy against the decision, permitting a review of the legality of that decision as regards both matters of fact and law. Therefore, the procedural safeguards in Article 31.1 apply. Now, as I said, that's the availability of the redress procedure in principle. But paragraph 50 and 51 answer the question of what is the content of the procedural safeguard, which, as I submitted earlier, is the question addressed by Article 31.3. The content of procedural safeguard for an extended family member is that they are entitled to a review of whether the national legislation and its application have remained within the limits of the discretion set by the directive. And then in terms of the fact, it's not a full factual review, it's contested decision is based on a sufficiently solid factual basis, that review must also relate to compliance with procedural safeguards, which is of fundamental importance, enabling the court to ascertain whether the factual and legal elements on which the exercise of power were present. And then what are those procedural safeguards? The obligation to undertake an extensive examination of the applicant's personal circumstances and to justify it. There is no reference to proportionality there. So proportionality does not come in via the Article 3.2 right in substance, and unsurprisingly, the right of appeal does not enlarge the right. There is that's what the right of appeal, or the redress procedure test. It does not enable proportionality review. So in other words, because there's an appeal, it doesn't turn into a different right. So that's my point there on the content of what's the EU law bounding. So for that, partly for that reason, we say that there's no scope for proportionality to come into it. To headline what I'm going to say that the Article 3.2 right doesn't change because of the UK's withdrawal. All Article 10.2 and 3 are testing is whether somebody has applied under that system and been facilitated, or whether they've made an application. But it doesn't turn into a different right, it's still the same right. The fact that there's a deadline means that there's a consequence, but that consequence arises as a right of exit. And analogously with the reasoning of check, it doesn't mean that the right turns into something else just because there's a deadline. So on to the second principle I wanted to establish, which is you can't get this right just by meeting the conditions, and nor can you get it right by saying you would like it. So can I ask court to turn to tab 29, which is Matters
Tab
29.
Yep.
Now, the facts are at paragraph 2 to 6, and they're relevant to show just how stark the consequences of the court's decision was. So, Mr. Matters was living unlawfully in the UK, and then he got engaged to a Polish national, and they got married on the 6th of August 2008. On 22nd of August 2008, he was granted a UA family permit as a spouse, because then he had direct rights of entry. And then unfortunately, he was convicted of a crime. So he begins living in the UK as a spouse on the 5th of September 2008. He then commits a crime, and the question that the court is looking at is what protection does he enjoy against deportation? If he had a right of permanent residence, there was a higher threshold which needed to be met before he could deport him, and the nub of it is at the bottom of paragraph 6. So the court says at E, he started residing lawfully in the UK until the 5th of September, but because he began his sentence on the 30th of August, he doesn't have a right of permanent residence because he falls 5 days short of the test. And what Mr. Matters says is, well, hold on a minute, before that I was in a relationship with an EEA national as a durable partner, so that time should be taken into account. Now, paragraph 11, the Secretary of State says, well, you've got an entitlement to require the Secretary of State to exercise your discretion, and to do that, the Secretary of State needs to undertake an extensive examination of personal circumstances. What the Upper Tribunal decides at paragraph 12 is, no, that's wrong. If the Secretary of State hasn't exercised their discretion, the Tribunal can do it, or, implicitly, the Secretary of State must be treated as having exercised the discretion adversely to Mr. Matters, because the Secretary of State was aware of his durable relationship. And the Secretary of State
coming here, he was here unlawfully, and they wanted to include periods when he was here unlawfully into the 5 years to get more protection.
Yes.
And what's going to be said against you is that he wasn't here unlawfully, but you say he was because the stamp doesn't do anything.
Yes, but what
But if you're wrong and the stamp does do something, then
yes,
it's not analogous.
Yes, I accept that. But what I say is when one is asking the question, what does the stamp do, and whether the stamp counts as facilitation, one has to look at the body of law, which decides, well, what do you need to do to get this right? And in Macastana, so if the court looks at paragraph...
Well, what we don't know is what the judge would have said if Macastone had left, come back via Paris, and then got the stamp, whether or not that period, we
yes,
just don't know.
Right, but if we had that case, we wouldn't be here, of
No,
course.
exactly. Yes.
Which is why this is so much fun. But paragraph 15, yes, it's being said, somebody has made a point, it's quite right, I'm being facetious, but it's not
Well,
fun.
would I actually enjoy this? Yes, nobody else
It's not,
does.
yes, it's not fun for the applicants, of course not, and I accept that, and I hope no discourtesy intended whatsoever.
I don't think anyone could reasonably have understood that.
Right, well that I'm afraid was the comment I had from here, so I wanted to make that clear. Thank you. So, yes, Mr. Macastana never made such an application. He entered the UK, blah, blah, blah. The Secretary of State was aware in paragraph 15 that he was in this relationship, and he actually got something on that basis. He got a visa disclaimer form at paragraph 15. But what's said at paragraph 16 is simply telling the Secretary of State about your durable relationship is not enough. And then at paragraph 17, and we rely on this passage, an extended family member can only be issued with a residence card if the Secretary of State has undertaken an examination of the personal circumstances. That has never happened and can only happen after an application for a residence card is made. Merely notifying the Secretary of State that one is in a durable relationship is nowhere near enough to constitute such extensive examination or to require such examination to be undertaken. So from that, we draw the principle that turning up at the border and saying, well, I'm an extended family member, let me in, is not an application. It can't, in my submission, as a matter of logic, be converted into an application because the immigration officer makes a mistake and thinks that the person should be admitted. So there is no application because that's what needs to happen for there to be an application. And then paragraph 18 considers CS Brazil. I'm going to come back to that because it might be thought to, it might be said to support the appellant. It doesn't in my submission, but I'm going to deal with it. And then paragraph 22 and 23, particularly 23, is the point that the facilitation of the matter for national legislation is the point that's picked up in the so the Secretary of State's national legislation isn't incompatible or inconsistent with the Citizens Directive. And then in the middle of paragraph 24, the sideline passage, it's the same point, which is, first of all, there's no criteria in the legislation.
So where are you reading from now?
Sorry, my lord, I'm going far too far. Paragraph 24, the sidelines.
Yeah.
2 points I take from this. First, Lord Justice Longmore is saying that, well, the legislation complies with the facilitation of it because it enables you to make an application. And then he also points out that an application has to be made if Article 3.2 was to be invoked. And we say no applications were made here at all because there's no evidence that an application was made. But certainly if somebody turns up and says, I'm an extended family member, that is not an application for the reason I just given. That's Macastana. And then CS Brazil at tab 21, which is in the other book. So this is a case that was decided before Rahman. And I'm just going to show the court, because it's not helpful to my case, and over the comment by Lord Justice Laws. Oh, is it? I might split my bundles differently. Apologies. It's tab 21.
don't know what you've been told, but what you told us was right.
Ah, that's good. So it's at paragraph 10. Now this is a case expressly considered in Macastema, but at paragraph 10, Lord Justice Law says, during the currency of this durable relationship, the appellant clearly might have approached the Secretary of State, asked for a residence card, or indeed asked generally for rights of residence under the community regime. Had such an application been made, whatever I mentioned, be its word or precise terms, the Secretary of State would then have been required to undertake a substantial examination of the appellant's personal circumstances. Now, the answer to why that doesn't help with appellants is threefold. The first is that is an obitur remark because the appeal fails. Second is that the court appears to have proceeded on the basis that at least to some extent the extended family member right was like other rights of residence under EU law, and that one takes from the submission that's made at paragraph 9, because there's a passage there saying any right of residence would have endured for 5 years, and a reference to Article 25. So that's a submission, as I understand it, being made that there was some sort of direct right, which led then to the obitur remark at paragraph 10. Now, I make no criticism, of course not, of Lord Justice Law, but this case was decided before Rahman, so before anybody knew about what was the content of the right. So the position, the correct position is as set out, we say in paragraph 17 of Macastema, is not enough to say I'm an extended family member. There has to be an application in accordance with national legislation. Finally, to go to Sadiqa, and that's at paragraph 43. And the part of the question in Sadiqa is it enough for the purposes of Article 10, 2 and 3 if you approach the Secretary of State, even if you might have said to the Secretary of State, I'm an extended family member, is that good enough for the purposes of Article 10, 2 and 3? And the court's answer was no. So, starting just the court's note at paragraph 21 to 24, just to say that is where there's a description there of the form and the documents available. I'm so sorry, paragraph 21 to 24, the sideline. And then the facts are at paragraph 26. So what Ms. Sadiqa did was go online and then she picked the wrong box. So she selected close family member and she confirmed she was applying for a plus family permit.
On the back, was she outside the United Kingdom? And she'd never come in and never been given anything to come in, so she was, wherever she was, trying to get something to come in.
It's trying to get something to come in, yes.
And
And then what happened, having submitted that application at paragraph 27, she didn't just, she added a letter saying, from her brother, saying, oh, I want my sister to come to the UK, she is financially dependent on me, which is in substance, as so it's argued in that case, a statement that there was an extended family member relationship. So that is another example of somebody saying I'm an extended family member, but as it turns out, that did not mean that there had been an application for the purposes of Article 10 of the withdrawal agreement. So
Where does it say that? Actually?
I'm coming on. Yes, I'm coming on. So I'm just paragraph 36. There was evidence in the Upper Tribunal that the brother had made a mistake. So there was evidence which we don't have in this case about what's gone wrong and why the appropriate procedure hadn't been followed. And then at paragraph 49 and 50, there was an issue the court was directly considering because of the way that Mr. took his case, he was the appellant, whether
Sorry, where is page,
Sorry,
paragraph?
page 1450.
Yes, thank you.
So that was what the court is saying is.
No, which paragraph?
Paragraphs 67 and 68.
Thank you.
Paragraph 67, first sentence. If an application has been purportedly made under the Youth Family Permit Scheme, when it is a matter of fact another application, it can be treated as such. Compare ECO and ARMED. That's why we take the point that whether or not an application has been made is a question of fact. And there is no evidence whatsoever to support Mr. Delamere's submission that an
Hang on,
application-
why is that? You just picking up on the phrase "as a matter of fact"?
Yes, because the court
What?
goes on to say at paragraph 68 that there's no, and paragraph 70, there's no basis for, so paragraph 68.
Yes, I see. Talks the UT referred to it being largely a factual decision.
Yes, exactly.
Just to decide what application was made, yes.
It says there was no, the tribunals below decided that there wasn't an application, and the court says that's a question of fact.
Yeah.
And then paragraph 70 is the conclusion that there is no requirement to treat application 1.
So sorry, I've just read. Where have we gone now?
Paragraph 70.
Yeah.
There's no requirement to treat application 1 as application 2.
Yeah. Just remind me how this helps with this case?
I will not get
Oh, right, sorry. Beg your pardon.
keep your lordship in suspense. If it helps to headline the point, is we say these cases are a fortiori, because if Mr. Zika, having made the wrong application, but at least having tried to make an application, having written a letter, said she was an extended family member, hadn't made an application, then somebody who simply turns up at the border and says, if this is what they said and we don't know, somebody who simply turns up at the border is equally not somebody falling within Article 10.2.
This then just about 10.3.
This case was about.
No, is this submission you're relying on in response to the
Yes,
claim that this was an
10.3.
application under 10.3, and you're not
Yes.
relying this the other arguments that it was in fact a decision facility.
Well,
It's just 10.3.
I am, because to get a decision you need an application, so it bites equally on Article 10.2. Because if there hasn't been an application, the residence has to have been facilitated in accordance with Article 3.2, and that starting point in that is an application, so it bites on that as well as Article 10.3.
There has to be an application to be granted. You can't have something granted until there's an application.
Yes. And then at paragraph 75, top of page 1.53, again, reiteration of the point that I'm making is that it's EU law provides that it's for domestic law to give effect to the rights of facilitation set out in Article 3.2, so long as the rights to facilitate and effect this are not removed. And of course we say having an application procedure is not removing or rendering less effective the right to facilitation, to apply for facilitation. And then 84 is the conclusion that she hadn't made an application for facility in essence, and therefore she didn't fall within Article 10.3, because she didn't make the application. And paragraph 86, we say this is right to accept.
Very odd. Doesn't matter. This is the official version. Is this very odd layout?
No, it's an odd layout. I
Doesn't matter. No, I'm sure it's.
I think it's the one that Lord Justice Diggins wrote on his own computer and in his own font, and that document was uploaded. He didn't use the template, I think.
I've seen it in an official version as well, in the template. I rather like your Justice Diggins font, but
It's a nice
there
font.
was-
No, okay, it does, as long as it's the official version, it doesn't matter. It just shouldn't appear like this.
There
But
are some odd pages.
Yeah,
missing,
okay.
I think.
No,
Certainly, if on Westlaw, I'm not sure why we've got this version, because it's
I printed it out from Bailey because I wasn't sure, and that was much more conventional.
Yes, exactly.
Doesn't matter. We can work with this one.
Yes.
Yep.
So paragraph 86, we rely on that reasoning here. We've established the policy to facilitate the entry of extended family members, and therefore we've complied with what is the substance of the right described in the dispositive in Rahman. There were clear criteria and clear guidance. And then paragraph 88 is my point about yes, there are serious consequences because of the cliff edge. The cliff edge being that there was a deadline in the withdrawal agreement. But as Lord Justice Bingham says, the withdrawal agreement was to give effect to the UK's orderly departure from the EU, not to preserve those parts of EU law which the UK decided should not continue to apply. It identified what rights extended family members would have and what rights they would not have. I'll show the court in a moment that the contracting parties to the withdrawal agreement specifically decided that Article 18 applications could be made late, but they did not do that for extended family member applications. So one can't approach the issues on the basis that the law is somehow different now that there's a deadline, is the headline point. So can I draw the strands together in terms of where we are in relation to the stamp, and my submission, my primary submission, that it doesn't confer any substantive rights on the appellant. So the statement in the passport is admitted under the 2016 regulations. The starting point as a matter of law is that that was not legally possible. There's two strands in my submission. There's a factual part, which is that something has happened, which is that a person has not been turned back as they ought to have been. They have been allowed to go through at the border. So at the border, you're either going to be turned back or you're going to be allowed to go through. That is what has happened by virtue of being admitted, because that's what the immigration officer could do. The immigration officer could say, I've read my guidance, I'm not getting my stamp out because you don't have an EEA family permit and I'm required to send you back. Didn't do that, instead opened the gate and let them pass through. So a factual thing happened. He admitted.
Well, that's clearly not what the stamp is intended to record.
I'm so sorry.
That is clearly not what the stamp is meant to record. The stamp is not a recording of the fact that they have physically gone through the gate. The mere fact that it refers to the regulations makes it clear that it's meant to be a statement of a legal state of affairs.
Precisely so, my lord, and that's why I said there were two bits.
I see, there's really only one bit, but still.
Yes, I think that the first point is that something happens in that you are allowed to pass, and in that sense, there is a decision.
It's not recording the fact that he's passed. They don't let him go through and stamp it. They stamped it, and because they've stamped it, then he goes through.
Well, yes, subject to, one has to remember that yes, I see your lordship's expressions of exchanges for those criminals don't matter.
No, I mean, he's looking at me and laughing with you all the time, but don't worry about him.
Yes, that's yes.
Yeah, ignore all that.
Yeah.
Yes.
Yes, you shouldn't be doing it.
Something has happened. That's going to now happen. And then, as my Lord of Justice Underhill says, it's a description of a legal state of affairs. You have been admitted under the 2016 regulations. So now, just in terms of the stamp is applied and then allowed through, as a matter of legal principle, we've had that stamp, but there isn't a requirement as a matter of EU law to apply the stamp. If there is a right of entry, if there's a direct right of entry, there's a right of entry, and that's the end of that. So
But isn't the position, we've now got a British person acting under British law, putting a stamp in a passport intended to have legal consequences. And isn't it for us as a matter of national law to decide what those consequences are?
national law, albeit case, one cannot, in my submission, escape the EU legal context, because what, as we've seen from the regulations and the directive, the only legal basis for admission is that there is an EU law right.
No,
So,
not for extended family member. It's a national right.
but there isn't a right. That's the point.
Well, that's the question. What is the... Something has happened in national law, and the question is, as a matter of national law, what?
Well, what has happened is that under national law there is no right of admission. That's the starting point. There is no right of admission. The only right is an EU law right, which is to come in as a direct family member. That's the legal position.
What has happened is that he's said under national law, I'm letting you in, and you're saying a mistake was made and you shouldn't have said that.
Well, yes, if yes, exactly. But the fact is, as a legal state of affairs, there was no right. And the question is, well, does the fact that somebody has a stamp saying they've been admitted under the 2016 regulations mean that, despite the fact there is no right under those regulations, they are nonetheless given a right?
Well, the question is, as a matter of national law, A, did the stamp confer a right, and if so, what right? B, is it now too late to go into that? And C, if so, where are we?
And the answer is no, because given that it's purporting to say there was an EU law right, it's precisely the same as betrayal and Diaz. Because if the immigration officer had stamped the passport and said, you are a spouse of an EU national and you enjoy rights under the 2016 regulations, that would be of no effect because of the principle in betrayer, which says that residence documents don't give you a substantive right to reside. So
Because you've got an EU law right, but you don't have that for an extended family member right, because they don't have a substantive right under EU law. They have a right to have facilitation, but not entry and admission. And what has happened here is somebody who's British has purported to grant a right of admission.
yes.
And it may be that when we analyse it, we might say, well, all he was trying to do was do what the reg said, and if he thought he was doing something under the regs and the regs didn't allow it, then he can't have been meaning to do it. But it does seem to me to be a question of interpretation of what that national action
Yes,
meant. And if it's not lawful as a national action, say he was bribed. I'm not saying that at all for these cases, but say he was bribed, then somebody could have challenged the ground and said, look, that's wrong. And that didn't happen.
yes, but the point I need to make, and I've made it, and I'll repeat it, is this, that there are two separate issues. There is a document which purports to say somebody enjoys rights under EU law, and there is the separate point that an extended family member doesn't enjoy any such rights, and therefore they need to have their residence facilitated in accordance with national law. Now, take Ms Diaz's case.
Can you say the second bit again, please?
How much is your lordship?
I've got a document purporting to say enjoy rights under EU law, and the other situation is
that an extended family member has no rights unless they are facilitated in accordance with national law.
Yes.
Now, that second point does not affect the first. So, take Miss Diaz's case. Now, Miss Diaz, the courts need to see the case.
Well, we weren't. Okay. Have we got it?
No, but it's the same as betrayal, it's just different facts. So, what the principle is, if you've got a bit of paper saying you've got a right of residence in EU law, which inevitably will have been issued under domestic law, if you've got that bit of paper, that doesn't mean you enjoy the right. So, take Miss Diaz. She stopped working, she was off work for 2 years, and so she didn't have any EU law right of residence. The principle that any bit of paper she'd been given under national law just didn't have any substantive effect.
so your submission really is, I think, when you read and seek to give meaning to the words admitted under EU regulations, whatever it is, we must say to ourselves, well, what the officer was trying to do was translate into the stamp the rights that were granted, but in fact there weren't any rights that were granted, so he can't actually have been doing anything.
It's declaratory, in effect. It's declaratory of a position which doesn't exist. And the reason the point I was making about Miss Diaz is, supposing, as well as having stopped working, Miss Diaz also might have had rights as an extended family member, which would need to be facilitated under national law. That would not affect the validity of residence documents, which says that she has a right of residence under EU law. The point is really, I'm sure I'm making hard work of it here, but the point is really quite simple. It's that the stamp in the passport is effect saying you've got rights under EU law as implemented in our legislation, because it couldn't have been saying anything else, because the regulations don't give any other rights. So
if it had been said, your rights are set out in the attached document and stapled to the back of the form, the passport, was a copy of the 2016 regulation, you say, well, there we are. He was purporting to give whatever rights the regulations give, and they don't give any rights.
yes.
But that's a question of the interpretation of the document.
Yes, so our primary case is that fundamentally this is declaratory, because what it's doing is setting out a right that derives from EU law. And
What
so
if we take a different interpretation, or what if we say, no, what the immigration officer thought he was doing and intended to do, he may have been mistaken, he may have acted otherwise, but if what he intended to do was to allow people to have the legal status of being lawfully admitted here, what's the position then?
one that to have the status of being lawfully admitted, it would require one to have the status of being somebody who was lawfully admitted, and these appellants.
No, that's what this is what the stamp meant. This is what the immigration officer thought he did. He's sitting there with him in front of him and he says, right, what shall I do? He's not saying, I'm going to declare whatever rights they are and push it off. I'm going to say, you are hereby admitted. I, the state, hereby admit you. If that's what he thought he did, and people acted on it, what's the position then?
The answer to that is if it's capable of having some sort of substantive effect, and your lordship has my primary submission, it's extremely limited. You're just admitted. In other words, you get through the game.
So if intended to bring about a legal consequence, the legal consequence was admission into the United Kingdom solely, and therefore it was not facilitation of residence.
Exactly. It's simply passing through the gate.
And on that analysis, admission carries no right of presence at all.
No, and indeed, given that the stamp simply says admitted, and given that there wasn't any right to be admitted, to construe it more broadly would be wrong in my submission.
It would be meaningless, though, wouldn't it, to be admitted, unless if a split second after admission, or as soon as the train drops the other side of the channel, you were present unlawfully.
That's why.
Well, but I know you don't accept the whole hypothesis, but once as a hypothesis has some legal effect, contrary to your principal view, it must be a right of admission and some sort of consequence right to be here. Maybe limited in time, maybe nothing that could have the character of residence.
Yes, in my submission, no. But if I'm wrong about that, and it's capable of having some sort of substantive effect, and if it goes further than what it said it was doing, which is simply being admitted, it can't, in our submission, get you more than you would have got if you complied with the rules. And that
But leave this to one side. You're trying to say always the stamp can only mean this because the rules mean that. And I'm trying to move you off that. And I'm trying to say a different hypothesis now in a different factual situation. The officer didn't care about the rules. And we're trying to get into his or her mind to work out if you're wrong and if he was purporting to grant something, not just allowing them to pass through the gates but not actually board the train, or board the train and not something else. We're trying to work out what he intended, what that stamp was meant to convey.
Well, that's the difficulty in dealing with hypotheticals, because if you made a mistake of fact, it was intended to convey one thing. If you got the law wrong, it was intended to convey something else.
But don't we have to look objectively and what any reasonable person looking at that stamp would mean?
If one looks at it objectively, the answer is the immigration officer thought that the person could be admitted under the 2016 regulations. In other words, regulation, it picks up the word admitted, that's regulation 12, it's regulation 11, that's simply about coming into the country. It can't, if it's going to be, if this stamp, using the word admitted, under the 2016 regulations, is going to confer a right of residence, then it would need to have had some extra wording which picked up other language in the legislation dealing with residents. So what the immigration officers thought they were doing was letting somebody in under regulation 11. They didn't say, and I also think that I'm giving you a right of residence under regulation 13 or regulation 14. What the immigration officers thought that they were just admitting them. And so if one's tracking the language of the 2016 regulations, what has happened is that the person has been admitted into regulation 12, but there is nothing to indicate that they've been granted anything else under the 2016 regulations.
Well, picking up your point, which I respectfully agree, it's perhaps not helpful to talk about what he thought he was doing, but simply what the objective meaning of such admission must be, such a stamp must be, if it was intended to confer some substantive right. I take your point that the only word that is redolent of a substantive right is admit, which obviously picks up regulation 11. But surely, simply because it is illogical to think you're admitted but have no right to be present, because that would be a completely empty right, it must also imply a right of admission and a consequent initial right of residence under Regulation 13. That's the only way in which you can square it with being under, A, making some kind of sense, and B, being under the regulations. Effectively, therefore, 3 months.
And it doesn't actually say admitted under Regulation 11. It says
No.
admitted under the regulations.
Yes,
Yes, but to be fair to you, you were taking the word admitted.
Yes.
It picks up Regulation 11.
Yeah.
Exactly.
But I'm putting the logic of the situation, once you've got that far, is that the reference to the regulations also necessarily picks up Reg 13, not Reg 14. Reg 13 is an initial right of residence, which is the inevitable consequence under the regulations of admission.
Yes.
That's how 13.1 reads. The EA national is entitled to reside for a period of not exceeding 3 months, beginning on the date of admission.
Yes, but that is a right that a direct family member will have.
Yes, well, fine. I mean, but if I absolutely accept this is your secondary case, but if you were not with you on your primary case, your secondary case can't stop at mere admission. It must surely be mere admission plus 3 months.
No, it does as a primary point stop at admission, because if one's going to be determining what we say is simply a statement, albeit the statement of the legal position, it ought to simply reflect the legal position. But the point I was going to make is, to the extent that it's going to be something more, it certainly shouldn't be something more than what somebody would get if they then entered law school. And that's to pick up on Madam Justice Lewis' analysis in the musical case. So, take for example, Mr. Vasa's case. He was told, this is what you need to do. And what Mr. Hasanaj's case in effect is, well, I should be in a much better position than if I'd done what I ought to have done, which was before I came, look up and see what I needed to do.
Well, that's extending it beyond what we're actually looking at here. That's making a broad point about the merits.
Yes,
and we've really moved on from that. I mean,
well, it is in my submission quite difficult to untangle given the various ways the case has been put against me. One of the arguments is, well, fairness requires that it be treated as that. Our starting point is it says admitted under the 2016 regulations, therefore it does no more than let someone into the country. Whether or not they enjoy rights thereafter has to be determined by the law, rather than a stamp, which is mistaken in law.
well, what I think my lord and I are putting to you is a much narrower point. We're not doing broad concepts of fairness, which I don't know how they would apply legally. And as you say, then the question is, well, it's all very well that the Secretary of State let them in when they shouldn't have, but it's his fault for turning up without the proper paperwork in the first place. Or put all that to one side and just do a rather more analytical approach based on what the natural reading of the stamp would be, ignoring the fact whether what the natural reading of the stamp might be would not apply, not be capable of applying in his case. And all I'm putting to you, and I think once we've done this, we must move on because you've had plenty of opportunities, is that the natural reading of the stamp is it allowed you to be admitted and it allowed you to have the initial 3 months residence.
And 2 points. My primary submission is no, all that the stamp does is let you into the country.
Yes.
What you do next is a matter for you. You might marry somebody instantly and then you'd have rights. You might say, I've had an outstanding claim for leave to remain. It lets you into the country, that's all it does.
Okay. Okay. So one, you don't know. It is purely admission.
It's
Yeah.
purely admission.
Okay. And 2.
And the second, if contrary to my submissions, it gives you anything, it certainly can't be any more than 3 months.
Okay.
And it won't surprise the court to hear me say that even if that is what it does, it isn't facilitation in accordance with national legislation. It's directly contrary to national
It depends how you define
That's
legislation.
a separate but important point. None of that would be facilitation in accordance with national legislation. It would be contrary to national legislation.
Exactly. My fourth topic I can take very quickly. This is about leave under the 1971 Act. I won't take up time with it because it's dealt with in our skeleton at paragraphs 31 to 38. We're like the main skeleton, which is the Vasa skeleton. The point that we've made, and the rule is there, and this is to deal with
Which is just meant for my note, which power of the Vasa skeleton?
31 to 38.
Yeah.
So this is the counter to Miss Savage's argument that there was leave under the 1971 Act, and I'll take that quickly.
Yeah.
This was a case where there was a prohibition in the immigration rules on granting leave to enter, for the reason given in paragraph 37 of our skeleton. So what we've accepted, yes, is in principle there could be a grant of leave to remain outside the rules, but that, as this court will know, is a residual discretion which is exercised in exceptional circumstances. There's no finding in these cases that there was such a grant, and there's nothing on the facts to suggest that this is the sort of case where leave would have been granted outside the rules. But more crucially, if he had been granted leave outside the rules, it would be endorsed on his passport.
Yeah.
Including the length and conditions of the leave, and it would also be recorded on the Secretary of State system. I can confirm that no grant of leave is recorded on the Secretary of State system. The other point, of course, is having stamped the passport thinking that he had a direct right of entry, granting leave would have been inconsistent with that right of entry, because there would have been a direct right, and therefore the person would not have required leave to enter or remain. So a grant of leave would have been redundant. So if the immigration officer, to admit under the 2016 regulations, the immigration officer had to think that there was a direct right of entry because there was no right of admission for extended family members. So the immigration officer must be proceeding on that basis, or alternatively got the law wrong.
But
if there is...
Sorry, I didn't mean to interrupt, but now I have. just as we were saying earlier, I'm not sure that the best way into this is speculating about what the immigration officer was thinking. Your better point, I'd have thought, is we know what, as it were, the objective phenomena are. This is not a grant of leave to enter, which we know what that looks like. This is explicitly something, whether you call it leave to enter or not, but something under the 2006 regs.
Yes.
And once it's that, it's not leave to enter because that falls outside the regime. Isn't that the real point?
Yes, I'll leave the final point. No, all the final point was about the two regimes not operating in tandem. If you
Yeah.
think somebody's got a right under the EU law, then you're not going to grant them leave to enter. So there wasn't that I could do. That's my answer to the there is leave point. And then turning to the withdrawal agreement, which is tab 1 of the authorities.
Yeah.
So Article 4.3, which is on page 11. And finally, we've got a withdrawal agreement with big writing rather than tiny writing. Article 4.3, the provisions of this agreement referring to union law or to concepts or provisions thereof should be interpreted and applied in accordance with the methods and general principles of union law. I've answered the intervener's reliance on this provision in paragraph 28 of our written response to the intervener. We're short of time, I won't deal with it in detail, but in brief, what we say is that what this says is when this agreement refers to EU law, you apply EU law. So in other words, the Article 3.2 right is the same right that it was under EU law. It doesn't turn into a better right simply because the UK has left the EU. Therefore, we say that the question that Article 10.2 and 10.3 ask is to be determined as it would have been determined under national law. And so that's why for Article 10.2 we say, well, under national law, you could never have made an application by simply turning up at the border and saying, treat me as an extended family member. And therefore, you haven't even got on to residents being facilitated. And I'll deal with those points in more detail. But what you can't do is say, well, yes, but it was exit, so it's all a bit unfair because there was a deadline, so we won't apply that jurisprudence, we'll apply something a bit different. That's not how it works. Article 18, I need to just deal with briefly because in writing at least one of the appellants has relied on it. The court has the ILA judgment. I won't take up time now with showing the court what it said about what is this resident status. But it would help the court to have paragraph references to the submissions that were accepted in this case. The IMA submission is captured at paragraph 84. The Commission's position...
Sorry, which paras?
84 is the IMA's position. The Commission's position is captured at paragraphs 88 and 89. Both will sing from the same hymn sheet. What they say is, look, all that this is a beneficiary status, a badge, as I described it earlier. The Secretary of State said, no, that's wrong. So, the reason that the Secretary of State said that was wrong is this. I've described some of the potential disadvantages of a declaratory scheme because what I've explained is that residence document under EU law is a snapshot. And so you can't tell if somebody has a right by looking at a piece of paper. You have to examine the facts and see if they meet the legal conditions. So the Secretary of State's position was, well, we wanted to get rid of that with the withdrawal agreement. We didn't want all this uncertainty. We wanted to get rid of a declaratory scheme because we don't know on any given day whether anyone's got any right. And what was the point in this residence document thing if all it was going to do was carry on the old system? And that argument is captured at paragraph 135H. by Mr Justice Lane at paragraphs 159 onwards.
Sorry, what was the reference again for secretary for encapsulated at?
The defendant's position 135H and Mr Justice Lane at paragraphs 159 onwards. So that's what this document is. Now, I think it's Mr Hasanaj's skeleton refers to 181D and 181E. These provisions are not about extended family member applications, they're about applications for this new resident status. And the court will see at D that the contracting parties decided that...
Sorry, I got lost here. Where are we now? Page?
Page 29, we're in Article 18.
Yeah.
It is still the point made at least in writing by Mr Netzer. Article 18D was relied on, but it doesn't give any extra time for extended family members, and crucially, it shows that where the contracting parties wanted to give extra time and latitude, they did so by express provision, because they've done that in Article 18.1d. And I think Article 18.1e was also mentioned, but that's about the beneficiary status document. It's not about an extended family member application. And then there's also been reference to Article 18.1r, and our answer to that
Well,
is...
before you go on, I in order. Now, I know you don't agree with all of this, and I've got all your submissions carefully written down. Assuming you lose,
Yes.
assuming we say no, this document must be read objectively this time, and it meant to grant legal status to admit, and it meant admit and live. What's your submission on 18.1L3? If that's what the document is, I know you say it isn't. 4, yes. What's your argument on that?
We've accepted in writing that if we're wrong, and it is a document within Article 10.2 or 3, then... no, sorry, I'm looking at M4. Let me just go to L4.
L4.
Yes, L4. Yeah, I've got it. Page 33. Yes, so I accept if I'm wrong,
Yeah.
and there was facilitation in accordance with Article 10.2, then I accept, and I have accepted this in writing, I think, that then there is a document issued in accordance with Article 3.2.
Right, so if the stamp does amount, we find, to the grant of
Yes.
admission, including residence, then you shouldn't have refused it. You should have accepted under 18L4, just so I'm clear, yes?
Yes.
Thanks, that's very, very helpful. So you don't even get proportionality under the other articles they go on about. Yeah.
Yes, so Article 18.1r, well, you don't get there if that's the way it's resolved, but if it's not the way it's resolved and I'm right, then you don't get proportionality, A, for the reasons I've given, because it's not built into the Article 3.2 right, and second, you don't get them under Article 18.1r, because that's a person who is entitled to the right. So Article 18.1r is saying the decision refusing to grant the resident status can't be disproportionate, but if you don't qualify for it because you don't meet the requirement in L4, then it's not disproportionate to refuse you.
Okay, assuming that the stamp wasn't constitutive of a right to be admitted and to live, to use a neutral word, but anyone reading it would have thought that. And Mr. Hasanaj got it, was very excited, didn't apply until June, because he didn't need to apply to the new scheme until the end of June. And then he's told, well, you can't get a new system permit. You should have had a family permit. He says, hold on a moment, I haven't got a family permit because you've given me a stamp in my passport. That's not separately disproportionate, is it?
No, in my submission, because if L4 says that the state is entitled to insist there's a document issued in accordance with Article 3.2, and there isn't such a document, it can't, in my submission, be disproportionate to do what the legislation says.
No. L says the host state may only require family members to provide the following. And if they do provide the following, then you can't ask for any more. And we've now moved into a different world where you're right on the interpretation of the stamp, but what has happened is somebody got the stamp, didn't factually need to get a family permit, and when they do then go and ask it to be translated to the new scheme, they're told, well, you're very foolish. The last thing you should ever do is trust an immigration officer and rely on the stamp. What you should have done is pocketed that stamp, gone straight to London and applied for a family permit as well. That's what
Yeah, so that there's
I'm characterising it, but that's the
so
argument.
there's two limbs to my answer, which is one, and it is repeating what I said,
Yeah.
but if we are permitted to require somebody to produce the document issued under Article 3.2, and there isn't such a document, then it's not disproportionate for that reason. But the second point is that Article 18.1r is, it doesn't expand the extended family member right. And as I submitted earlier, there's, in terms of whether or not you qualify for the extended family member right, there isn't a proportionality test.
But the thing is, on one reading, you could say this. You could say, well, they wouldn't have got the stamp unless the immigration officer thought they met it, or at the very least, they would have had a good chance on the facts of these cases of satisfying the family permit. And by the grant of the stamp, they've been deprived at the very least of showing that they would have met it. And the fault lies with the fact that, rightly or wrongly, the immigration officer didn't do what you say he should have done, which is said, get thee gone. He stamped and let them in. And you say that doesn't matter, that's just unfortunate, but that's just life.
Under the withdrawal agreement, the test is in Article 10.2 and 10.3. If the person doesn't satisfy that test, then they're not within scope. So we can't rely, in my submission, on Article 18.1 because they're not within scope of the withdrawal agreement. Article 18.1 applies to people who are within scope because Article 10 is a scope provision. And that can be seen on page 18. So in my submission, it has to be one way or the other. Either they come within scope because what's happened in Article 10, 2 and 3 has happened, or they don't come within scope and they can't rely on Article 18.
So there's no separate need under EU law to use proportionality or anything else, because you only get to EU law if they're into 10.2, and on this analysis, they've lost on 10.2.
Yes, and I should say it's withdrawal agreement law, and no, you don't get the benefit of the right to the withdrawal agreement if you're not within scope.
Can we do it under domestic law and say, well, this shouldn't have happened, this should go around behaving like this, so we'll quash the refusal as a matter of domestic law?
No, because the ground for appeal is breach of the withdrawal agreement.
Oh, that's right, yes. So that's so remind myself of that. So you'd have to have applied for judicial review. Right, okay. That's very helpful, thank you. It's very Article 8. It's Regulation 8, isn't it, of the regs?
Yes.
Yep. No.
And then Article 21, safeguards and right of appeal. Our point on that is if you don't, if that's about restricting resident rights of the persons referred to in Article 10, so it doesn't add anything. If you're not a person in Article 10, you haven't got any right to restrict, so it doesn't add anything. So far as the extended family member right is concerned, the procedural right is the right in danger. And so far as Article 18 is concerned, the question is, are you or are you not within, you can't take the benefit if you're not within scope. So you, in other words, you have to have the right first before you can complain about having lost it. So then, having made all of those submissions, I can now address why we say that these appellants don't fall within Article 10, 2 and 3, and that's to bring together the submissions I've been making as I've been going along.
Yes, thank you.
So, point 1, we accept that Chellick doesn't address this specific situation, but nonetheless, we commend the excellent analysis of Lord Justice Lewis at paragraph 60 fall in, and that of course is consistent with Max Taylor. And so far as Mr. Vasa is concerned, I'm really saying Mr. Delamere was quite right to recognise this. Paragraph 95 bites. In other words, he had a refusal decision.
So para 95 of Chelik.
Of Chelik.
Yeah.
In that sense, they're both in the same position. Both had a refusal decision which they didn't appeal.
Well, the difference is Mr. Chelik then didn't make another application within time, but Mr. Vasa did.
No,
He didn't, did he?
no, he didn't. He made, so Mr. Vasa makes his application, it's rejected on the 23rd of October 2020.
Yeah, that was the first one, and that was the first USS
And then,
one.
yes, and then he makes one after the end of the transition period. I think it's in
I
March.
thought an EUSS application could be made up until the 30th of June, and that's
Yes.
what he made.
He did, yes.
Chelik was whether you could treat the EUSS application as a family permit application. That was what they were trying to argue for there. But here, he is allowed to make a second application up until the 30th of June, and the question is whether you should refuse that application because he produced the relevant document. Just follow
Yes,
me.
yes, I do.
So in fact, 95 doesn't apply, does it, in that case?
Well, I think our answer to that, of course, is then, but he was told on facts that he needed to do that, and so any fairness type argument or any whatever
But
argument.
you would say, I don't have to do that. I've got it. Why are you making me do something under the 26 regulations when I don't want that? There's only a couple of months left. What I want is the new one. And my claim is I don't need to go through that to get the new one. That's why this is all a bit of a red herring.
Yes, but that depends on how, if the court is to decide that the standard did something, the route by which the court gets there, because if it's by reference to fairness or proportionality, then that is obviously a crucial.
That's part of that analysis,
It's
yeah.
also relevant, we say, to the language of Article 10.2, which is.
So are we still on your first point?
I've been diverted by a question. Before I go into my points, let me just. That was my point.
But your first point also, it's always by definition a marginal point, isn't it? You accept Chelik doesn't directly apply here. You're trying to get some marginal assistance out of it. It's not really where we want to be spending our time,
No,
is it?
point taken. But I do also make a point. I think one has to read all of these authorities as a whole, and the weight of authority, and we say the same about Speaker, the weight of authority, Macastana, Speaker, other cases, is that you look at, when you're deciding whether somebody has applied for facilitation and whether they've been facilitated, you have to ask, have you applied under national legislation and has your application been granted? And that has to be after an exercise of discretion. That's the position under national law. That's what Macastana says, and we submit also what Speaker says. But fundamentally, it's what Macastana says. And so, our primary cases, those things haven't happened.
Sorry, it started great. First point. Is this part of the Chelik point, or have you moved on to your main point?
It's really our. Thank you. It's our.
So what is the proposition? Drawing together the threads. What are you saying?
The starting point is that if a person is to be treated as a person who has been facilitated under Article 10.2, they need to have made an application in accordance with national legislation, and that application needs to have been granted under national legislation. Macastana says so in terms. We submit that Sadiqa says so in terms. That is what Article 10.2 and Article 10.3 require. Now, the reason that we say that as a primary point is because what Article 10.2 says is that your residence was facilitated by the host state in accordance with its national legislation before the end of the transition period in accordance with Article 3.2 of that directive. So what that does is under the national legislation you have in place implementing Article 3.2, has your residence been facilitated by the host state? And that picks up the language in the directive. So facilitated isn't some new...
Well, it depends whether you're putting a lot of emphasis, understandably, on national legislation, but it could be said that it's really the boots on the other foot. The real question is, were your entry or admission or residence facilitated under 3.2, square brackets, in accordance with your national legislation, because we recognise, having seen Rahman, or in fact you don't have to see Rahman, it's actually in 3.2 itself, that the actual way you do it is a matter of national legislation. But the right is fundamentally a right under 3.2. So it's not crucial that it be under your national legislation. If it was effective, well, no, I'm expressing myself badly, but the focus is on 3.2 rather than on national legislation.
It's not in my submission, and 3.2 doesn't have any meaning without national legislation, because that's the right. The right is effectively, you need to find a way to do these things under your national legislation. It's a limited right to have an application considered and the procedural standards I mentioned. So it's meaningless without...
I see that.
The problem is, when they say national legislation, what they're saying is you've got to solve this at a national law level, not at an EU level. And if all had gone smoothly, they'd have been turned away and they made an application for family permit. But part of national law is when a public body does something and screws up, national law's got to sort it out. And that is in accordance with national legislation. If you have to, Section 31 of the Supreme Court or whatever it is. But the point is, national law is left to national law. And Article 2 isn't saying, and you can't do it unless you can show that the implementing legislation itself has done it. You would never say that.
That puts it much, that's what I was trying to get at,
Yes.
but much less well.
Yes.
No, I didn't get there, but my Lord did.
Yes, and understood, but the starting point, first of all, is that national legislation says this is what you need to do to be able to reside here and get a residence card. That's what it says, and it says that for good reason. So if one is to say, well, actually, some other principle of domestic law comes in and says something else, one then has to identify the domestic principle. One has to do it against the framework of EU law, and that comes back to my point about saying whenever somebody's told they've got an EU law right, that always has to be done via national legislation, because that national legislation tells you how the bit of paper gets issued. But EU law's got an answer for that. EU law's answer is if bit of paper under national law says you've got a right and you haven't, that doesn't matter. That's not a right. So
That's Petrie.
That's Petrie. So there's an EU law answer to that question. What all the Article 10, 2 and 3 are doing are looking at who are the people who are caught by this withdrawal agreement. They are people who have applied under the state system or have made an application that hasn't been decided. So we say it really is simple. It's the pre-withdrawal agreement law. You look at what the position would have been under pre-withdrawal agreement law, and the answer to that is, well, there's no application to turn up an order, and in accordance with its national legislation, there's a requirement for an application. So that's really the point. It's a principle of what Article 10, 2 and 3 require is, have you applied under national legislation implementing the extended family member right, and has your application been granted? I'll come back to the point, well, domestic law does something else, because I think I've answered that in saying, well, it doesn't actually, and if it does anything, it just, because this is a statement of a legal status, and the Majora principle doesn't fight on a statement of a legal status because it's not a decision. If it is a decision under national law, it's simply to let you through.
Well, we've had
We
that.
made that. We
We've
made
had
the
that, yes.
time short.
So the various points then to address various arguments. I've made the first one already many times. All that happened is that they were permitted to enter. I've made that point that stamping somebody and saying admitted is not facilitating their residence. And the next point we make is the idea that when the domestic state has set up a system for good reason, which requires an application and which says you can't come in if you haven't done that, the idea that a mistake happens, which is otherwise than in accordance with that national legislation, is still facilitation in accordance with domestic law, we say is wrong. It's flatly, everything that happened here was flatly inconsistent with national legislation. It shouldn't have happened.
Yeah, but EU law doesn't care about that. National law does.
Well, the withdrawal agreement cares because it says in accordance with its national legislation.
Now, well, do you think you're putting a great deal of weight on legislation? You say that it doesn't cover a case where national law would recognise these people had legal rights outside the legislation because of some idiosyncratic circumstances, such as here, maybe that the interpretation had been the legislation had been misinterpreted, but the person had relied on it. They aren't given any rights by Article 10.2. That would seem surprising.
I'm sorry, I missed the first thing that your lordship said. I do apologise.
Well, you are focusing specifically on national legislation, and you're saying, for reasons that we well understand, that this situation is not covered by national legislation. My lord has put you earlier, well, it may not be covered by national legislation, but it is covered by national law, or potentially covered by national law. An example of that would be where the state authorities has misrepresented what the position is under national law, and the EEA national or family member has relied on that. Forget whether those are the facts here, but that would be an illustration of national law giving them rights, because under national law you wouldn't be allowed to go back on the position as it was represented to you, or as you represented it, but national legislation wouldn't. What I'm wondering is whether the focus you're putting on the word legislation is too narrow. Whether if we were in Brussels, which we never will be, Luxembourg, if we were in Luxembourg, they would say, come on, national legislation actually means national law, because that's what we're concerned with here.
Yes, I'm not putting emphasis on the word legislation. In fact,
That's helpful.
I'm putting emphasis on in accordance with, because my headline point is everything that happened here was not in accordance with domestic law.
Well, it wasn't in accordance with the regulation, you see. It might be in accordance with fundamental principles of administrative law, that if you do something and it's wrong, you sort it out. That may be what national law requires.
Yes, and that comes back to the fact that my second point, which is, well, what if the stamp is doing something, what is it doing?
Yes.
And
Well, then we come back to that point, but in a sense, this stage of the argument, you've lost on that.
yes, I accept that, but that's the secondary point. If the stamp did have some kind of legal effect, and nobody's actually pinned down what that was, even if it somehow entails a short period of residence, in Mr. Hasanaj's case, that period has long since expired by the end of the transition period. So if he got 3 months of residence, that ended in June 2019.
If that's what it meant, or it could mean. Residence initially for 3 months, but so long as he was a dependent relative.
Yes, if that's what
It could
the
mean
stamp
that.
meant.
That might have been what would have happened if he got the family permit. But he'd have come in, even if he hadn't got a residence card, what would happen to an extended family member with a permit? They have to leave, have they?
Yes, otherwise, no, he would need it. That's the point we've made in writing. Because even if he'd had, and he took it by respondent's notice, even if he had had an EEA family permit as he ought to have done, it would have expired by September 2019.
And if they're not enforced.
It's 773.
Yeah.
So what he's doing is effectively being put in a better position than somebody that applied for an EEA family permit before they came, or entry clearance, which would have been open to them, and who then applied for a residence card, as they would need to have done, otherwise their residence would have been unlawful. And simply by virtue of this stamp, which all regulations, he gets to bypass all of that and in effect get some kind of residence in perpetuity. And we say that's wrong.
We don't. The first part is fine. The second part we don't know. We've got to decide what it means. And the second part is we mustn't forget that he didn't get anything. He was given something by an immigration officer.
Yes, he was, but part of the context is that if it's right that he enjoyed some kind of ongoing legal residence, it puts him in a better position than somebody who regularised their situation who would not have had lawful residence after September 2019. Now, the question is what effect did the stamp have? Mr. Delamare's case is, well, it was just an application,
Yeah.
so his case isn't based on the legal effect of the stamp. A learned friend says, well, it was leave. I've dealt with that. I'm not sure what Mr. Metz's case is or what's the legal effect of the stamp. At the moment, it's the court proposing. I'm not actually answering the case.
No, I do understand that.
So my answer, although it's in a bit of a vacuum, is the answer is if it has any substance. I've answered. I'm not going to repeat what I've said.
But do you feel you've had the opportunity, in fairness to you, because this has been put to you by me?
Yes, but it rather depends on what other people say when they stand up, because it's put to me by the court. But if Mr. Metz or Mr. Delamere stands up and says something else, I won't pass it. But we can cross that bridge perhaps when we come to it. But I have answered it in saying doesn't have legal effect. If it does, then it's very limited, and it certainly isn't. It's nothing more than a short period of residence, and it can't, given its terms, be anything other than something very limited.
Yeah.
So that's in effect what we say about Article 10.2. Can I just deal specifically with Mr. Hasanaj? His residence, the idea that his residence is in accordance with national legislation in circumstances where had he applied lawfully, it wouldn't have been after September, we say is wrong. He was actually, and the reality was that he was residing here as a matter of law, subject to the effect of the stamp, but he was residing here as a matter of law without leave to enter or remain and without having regularised his position. So his residence, we submit, subject to the effect of the stamp, was directly contrary to national law.
So he was an illegal immigrant.
Why are you making a difference to Mr. Hasanaj and Mr. Vasa in that
Well,
respect?
sorry, I was about to come on to his case. The answer in Mr. Vasa's case is whatever effect the stamp had, and this is to pick up perhaps the analysis in the duty code type situation, once he was told in terms, and as the court...
Yeah, but instead of that, we take this more shortly. I mean, Hasanaj and Vasa are both here unlawfully for the reason you've already given on your subject to the effect of the stamp. They don't have leave to enter, they don't qualify under the regulations. And in Mr. Vasa's point, there's a further point.
Yes,
Yeah.
which is if whatever the effect of the stamp, and he didn't appear to construe it rightly as entitling him to reside here.
Yes, he did. He didn't come in for a residence card. That's why he didn't. He came for a EUSS card. He wanted the new document.
Yes, but he wouldn't have needed that if he had a right to reside under the stamp. He wouldn't have needed to apply.
But he would eventually, once the 30th of whatever date,
Yeah.
the 30th of June, he'd get him ready.
Well, it depends on the effect of the stamp. My learned friend's case is that he had in effect indefinitely to enter. But once he's told this is what you need to do, then plainly his residence is not, even if it has been in accordance with national legislation, it's not anymore.
Well, okay, but I maybe you're right about the effect of the case being advanced about indefinite leave to enter, but you've got to meet a more moderate version of the case, that they had some sort of right short of indefinite leave to enter, i.e. some sort of EU-derived right, and if that is the case you're facing, doesn't it follow that to rely in Mr. Vasa's case on the fact that he did apply under the EUSS is neutral? Because anyone with an EU-derived right would have to apply under the EUSS before the 30th of June 2021. It'd be very different if he'd applied straight away for an EA family permit, but that's not what he applied for, I believe.
No, but he was told that he needed to, and I don't want to rehearse points.
Well,
I think it answers
was he told he needed to apply for a residence card in order to continue living there in October, November, December, or was he told that he needed a residence card for the EUSS
I think,
scheme?
in fairness, it's the latter.
Yes, in that case, then he wasn't told he needed to live. He couldn't even live here unless he got a residence card.
No, although had he gone to those pages,
Well,
found that out.
it doesn't matter. It's the letter. It's what you
Well,
told him.
one has to, in my submission, be cautious here because it is a general situation that not knowing what you need to do doesn't mean you don't need to do it. So
No, I understand that, but you're saying he was told this, and what he's told, page 25, is until you hold such a document, a residence card, you cannot be granted leave until the EU settlement scheme.
Yes.
So he wasn't actually told, don't forget, you're here unlawfully, you must go immediately.
no, I accept that.
No, but anyway, I understood you to accept earlier, I think obviously correctly, that you accept that if his right was EU derived, an application for EUSS, or under the EUSS, is neutral, or does.
I'm not sure I'd go that far because I'd say one's looking at the state of facts and the fact. Can I just make a preliminary point, which there were two questions in the background here as I'm addressing things in a vacuum. First is what does the stamp mean and what did it confer? And the second is there some general principle of domestic law which gives you something? And the way that it's analysed rather affects whether or not these are relevant factors. So I think I have to say that is relevant. It depends on precisely how it's analysed. The difficulty I have is I don't have respondents.
I see the difficulty, but I think you ought to be able to deal, at least with my lord, perhaps less with me, with the points that we put to you.
Yes, understood, and I am by saying A, it doesn't have any effect. If it has any effect, it's minimal. And simply looking at what Article 10, 2 and 3 do, my answer is that getting a stamp which has been applied without any proper basis for doing so is not residence in accordance with national legislation. It's not facilitation of residence in accordance with national legislation. It's making a mistake and letting someone in. And one has to, in my submission, when one is construing Article 10 to remember that EU law does not look favourably upon mistakes or things that...
Well, yeah, there is a risk that you're coming back to Petre, and this is ground we've been over before.
Yeah,
so what I'm see the time, and I won't promise that we will shut up if fundamental points are made, but I think you want to make sure that you address in the remaining time available to you points you haven't had a chance to address, rather than going over them again.
Yes, but can I just say, in relation to the interpretation of Article 10.2, my submission is that it has to be interpreted in light of the EU law fundamental principle described in Petraea about the nature of residence documentation. And Article 4.3 would, in my submission, require that is taken into account. And so, from an EU law perspective, anybody with EU law eyes looking at this will say, we don't care if it's a mistake, we don't care if it's the national member state's fault, it simply doesn't mean anything. So, in answering this Article 10.2 question, it is highly relevant in my submission that is the view that EU law takes about mistakenly issued residence documents, and in substance,
We have taken that point on board.
Yes, but so that's why I bring it up again here, because we submit it's relevant to Article 10.2. So that's Article 10.2. Article 10.3, the submission that the application was still outstanding, dealt with in our written response to the intervener at paragraph 5 to 16. Can I just draw the strands together as follows? 1. Whether an application has been made is a question of fact. There is no finding to that effect, and no evidence capable of supporting it. All we know is that they appeared at the border and the passport was stamped as admitted under the 2016
Miss Smythe, I do apologise for interrupting, and I do understand how important it is to get the points across, but you're now in an area sometimes of repetition. Do you really want to make your headline points?
Yes. So I'm just drawing the strands together.
Yep.
So thank you, Melanie. I appreciate that. That's the first point. Second point, the point I made earlier, which is you can't make an application by turning up at the border. And see paragraph 59 of our Vasa skeleton as to why the rules aren't set up in that way. Third point, if there was an application, this is Mr. Dale's point, it was an application to be admitted, but they were admitted, so that application has been dealt with. There's no point in granting them an EEA family permit, and in fact they can't be granted one because they're out of the country. But in my submission, turning up at the border and saying, if this is what happened, I'm an extended family member, is not an application for residence. And then finally, the reality is, if you can turn up at the border and make an application, it's going to fail. Because you're not going to be able to, if you just say I'm an extended family member, inevitably your application will fail, because it would need a whole load of supporting material. So if an application has been made, it was one in my submission that was destined to failure, and the Secretary of State would be entitled to say, when you turned up at the border, okay, I'm required to treat that as an application, but you haven't supported it with anything because you just turned up at the border. I will finish in time. Fourth, we say that the proportionality is about to play an answer in the Article 10.2 and 10.3 question. I'll deal with that specifically in a moment. And then that's really it on those points. So that's Article 10.2 and 10.3. And then can I address various other arguments that have been put? I've made the point first that the question is not a free-floating one, but a question of why refusal breached rights under the withdrawal agreement. The first point we make in relation to various of these arguments that have been made about general principles of proportionality and fairness, that if the appellants wanted to build a case of fairness, they should have marshalled the evidence to support it. There's all sorts of gaps in the evidence and all sorts of questions that the Secretary of State might want to test on cross-examination if this has been determined on proportionality principles, like why didn't you apply before you came? What were you doing between the period of March 2019 and December 2020? Because for all we know, somebody might answer that by saying, I just couldn't really be bothered. We don't know. And so to say that this court can say that it's disproportionate in these cases to refuse the application, my submission doesn't fly because there's no evidence to support it and there's gaps in the evidence. As to proportionality, I've already made my submissions about why it doesn't apply, but even if it does apply, here's our answer, and that answer falls to be determined against a legal context and a factual context. The legal context is the legal context I've given. A, the approach of EU law to residents' rights to betrayer. B, the legal context is a finding by Max Dana and Sadiqa that the system we introduced met our obligations under Article 3.2. This is the legal context for a proportionality consideration. And third, that national immigration law places importance on third country nationals regularising their status. So that's the legal context for consideration of any proportionality case. The factual context, it won't surprise the court to hear, I don't want to repeat myself, but the four features are no steps taken before entry, never being explained in either case. 2, the stamp only said admission. 3, know that he was here from March 2019 and he didn't do anything to regularise his status as he would need to have done if he'd applied for an EEA family permit. I'd add into the mix when considering proportionality that there's plainly nothing disproportionate about having a system for applications and about saying, well, people shouldn't just be able to turn up at the corner to make the application. So on these facts, against that legal context and factual context, it is not disproportionate to insist on the relevant system, which is under the 2016 regulations, to be complied with. To answer the point from Mr. Barnett, it's not a case of, and I think I'm quoting him, praying a state's own effective system, because there isn't an effective system. A mistake was made, and at the end of the year, I'm sure the court will ask us to deal with anything further that needs to be dealt with, including provision of guidance. What the principle of proportionality does not require, that if you make a mistake, you perpetuate it by ignoring your own domestic rules and putting someone in a better position than if you had never made the mistake and if they had complied with their legal obligations. And that's the point about the point on the facts. And then finally on proportionality, it doesn't require, in this context, that you treat them as having made an application or that they haven't made or as having residence rights which they didn't have. As to the principle of legal certainty, our answer on that is simple. We say that requires applying your own legal rules and treating people fairly rather than a simple mistake which says admitted, putting you in a much better position than other people who have tried to comply with the rules. Now, there have been a lot of points made in writing and orally. Obviously, we rely on our three consolidated skeleton arguments, and our points are set out there. Could I have a moment?
Yes.
So from us, there are...
There's really two live skeletons, aren't there? There's your response to the interveners.
Oh, there's a response to the you're calling that discussion, yeah. That's
Yes,
fine.
sorry, yes,
Okay,
response to intervener and the consolidating ones that we've done in response to the late skeleton.
Well, thank you very much, and well done for getting in all your points extremely cogently within the time available. If by whispering there's been sufficient coordination to proceed straight to replies, we will do that, but particularly as Ms. Smythe has given you an unexpected 3 minutes, we will rise if it will enable you to coordinate who wants to deal with what. But you may be there.
My Lord, my Lady, I'm very grateful for that indication, but between the three of us, we have attempted to cooperate while taking note of Ms.
Well done.
Smythe's
Best traditions of the bar. Okay, well then, who we can hear from first?
So you'll hear from me first, and I
Yep.
won't take up much of your time, and I haven't discussed this with my learned friends, but broadly, we'll all have an equal amount of time, which I hope will be of assistance. So, first, in relation to Vasa, the first point to make is in response to my Lord Justice Lewis's point about whose appeal is it and where are the grounds, can we have those identified? So would it be most helpful if I were to give you the references, or would my Lord like me to take the court through the references of where...
Or even write down on one side of A4 the paragraphs in
Yes.
the document that contain the thing that we've been asked to
But
decide.
I mean, I don't know how much time you want to take on other points, but if this is really the main burden of your reply, the best thing would be just briefly, I would have thought, now, to take us to where we find the core of your case.
So the respondent's skeleton, the respondent's notice is in the core bundle, and it's tab 25, 224. It's in fairly short terms at page 226. So we're asking the court to uphold the decision decision on different grounds, and those are finding that the immigration officer entry, that is the stamp, didn't amount to facilitation.
Sorry, where are you reading from?
From 226, section 6, the grounds of appeal for upholding the order. So those are our grounds.
Yeah, but there's no need to read it out.
And then that's followed by the skeleton argument that's provided with the respondent's notice, where the two issues are set out, and they are exactly in the way that they have been presented before.
Sorry, again, I'm slightly behind you. Where are we going now?
I do apologise. So this is the skeleton argument, page 246, the following tab, tab 28, and it's paragraphs 36.
Oh, I see. I thought this skeleton had been replaced. I thought totally.
Yes, it had been.
So what is it?
has
Is it
been
worth our
modified.
going to it then?
My lord and my lady, I only need to take you to this because
Okay,
it
all right.
encompasses everything that we wanted to say. We perfected it and amended it and produced it. But those were our grounds.
Which page, sorry, Mr. Page is the excitement?
I beg your pardon. So that is tab 28.
246, you say.
246 is paragraph 36.
246 to 251. So those are the two grounds 1A and 1B, and one.
Sorry, in what's it? What's ground one come from?
So we reformulated the respondent's notice.
Yes.
So we are asking the court to uphold on for reasons different than that those given by the Upper Tribunal into issue 1A, which is essentially our ground 1A, broadly corresponding to the Secretary of State ground 1C, and my lord will remember having an exchange with my learned friend about that.
Okay. Now I just wanted to know. So
And in some
these
ways,
grounds are not referring to grounds that are pleaded anywhere else. This is your reformulation.
yes,
Okay, thank you.
and those are broadly, there was facilitation under Article 10.2 because broadly there was facilitation under the 2016 regulations and under the 1971 Act.
Okay.
And the second ground was, in any event, even if there wasn't lawful facilitation, lawful grant of leave, then it would be disproportionate to consider this as anything other than facilitation. So that's the reason I hope it clarifies why there wasn't any difficulty, certainly as between the parties, about what was going to be argued in this appeal.
I mean, there was. No one's referred us to it except referentially through the skeletons. A schedule of issues agreed
There
behind
was a schedule.
tab 30,
Yes,
pursuant to a direction given by Lady Justice Andrews.
yes.
Nobody's asked. That's not an authoritative place to find the case as is now put. Is that right?
It's perhaps not unfair to say that that's not the most helpful way
No,
of
good.
formulating
That's
it.
fine. Good.
So that's by way of procedure. The second point is just a factual one. I don't want to spend too much time on it.
Just
but
one
just
moment.
on the facts in Vasa in relation to what happened at the border and whether it was possible, first of all, for the immigration officer to have considered that Mr. Vasa was a dependent on his father. I just want to draw to the court's attention the fact that there was a stamp on the father's.
But he didn't come. I thought the whole point of what we went through this yesterday, that everything he said, right up until you spoke yesterday, was I came as a dependent of my brother. So
Yes.
why are we back to the father?
No, my lord, I'm not making myself clear. There was a proposition, a factual scenario posited, where the immigration officer may have mistakenly thought that the father was the EEA citizen and that the child.
I think I suggested that, but it was merely speculative in order to test various things. Nobody's going to make findings as to what happened here.
I only wish to draw to the court's attention the fact that there was a stamp on the father's EUSS family permit, and that sheds further light on what the immigration officer had in mind as to the family composition.
You know, and I know, Steve, we assume all three of them were standing in front of the same officer. Do we actually know there's one officer that put the same stamp on both passports, or do we not?
We do.
We don't have that.
Well, I can't even link that as influence. Can I? On the evidence?
It would be remiss of me to invite.
But anyway, with respect, it's an exercise that
Yeah.
doesn't go anywhere.
No.
It was a thought experiment, not a basis for a finding. Yeah.
My Lord, I'm grateful. Just the second point in the factual situation, Ms. Smythe drew the court's attention to the fact that dependency was never formally accepted by the Secretary of State. It's right to say, on behalf of Mr. Vasa, that the decision to refuse the EUSS application could have been, but was not refused on the basis of dependency. And equally, the presenting officer could have challenged dependency at the appeal, but that wasn't the way the case was charged.
So what?
Well, precisely. So one can't say that this was a case where dependency was challenged in any particular meaningful way. Just one point in the case of Petraea, and you will be addressed on it by my learned friend, Mr. Delamere, but we make submissions at paragraph 42 of our skeleton argument, most recent skeleton argument on Petraea, and I don't want to invite you to read that now, but I would invite you to take that into account as to why it is not on the point. My Lord, my Lady, my last point is in relation to the definition that the Secretary of State urges upon the court in relation to the word admitted. And all I wish to say is that that interpretation is correct, if correct, is directly contrary to the principle of McCarthy, and indeed to the only explanation that the Secretary of State has put forward before this court as to the existence of the stamp. And if one remembers, the existence of the stamp is said to be in order to evidence admission for direct family members who don't hold a residence document or a residence card. Otherwise, there wouldn't be permission. Well, if that's the case, then the admission cannot be to evidence something that is simply letting them through the gate. It has to include, by definition, under EU law, something more than presence. And in my respectful submission, it follows that it includes, obviously, residence. My Lord, my Lady, that's all I have to say, and all the time I wish to take up.
Very good. No one ever objects to such lies, Ms. Davies.
My Lord, I hope also to be very short. Two I hope, short points. One, a question which was posed by my learned friend, and which Lord Justice Lewis grasped, but I think we need to just spell it out. The case in Mr. Hasanaj, which is also contained within our skeleton, which I needn't go to now, is that Mr. Hasanaj thought he had a relevant document, namely the stamp, so he needed a document to apply by the end of the period, the 30th of June 2021.
Is there any evidence about this?
It's evidence the other way. We have no direct evidence from Mr. Hasanaj, as the court appreciates, but the case is that he had the stamp comprised, and that's on the law what we respectfully submit, comprised a relevant document, and that the application needed to be in by the end of the transition period, the 30th of June, and he needed therefore to apply, and he met that by 24 hours before, on the 29th of June, with the stamp that was in his passport.
Well, we don't know whether he was, in inverted commas, I'm not suggesting he was playing the system, we just don't know what he was doing.
I can't put, and I don't put any evidence, but we respectfully submit that there must be a clear inference in relation to the date that was selected for the application being the 29th of June. My Lord, I can't take it further evidentially, but my respectful submission, that is the case based upon what we do know without contradiction in terms of the chronology. As far as the only other point I was the Sadiqa point, I think this is perhaps important. Can I take my lords and my lady to Sadiqa? It starts at 1429. Authorities bundle. There are 5 paragraphs I'm going to just direct the court to. The last 2, the only one I need to spend any time on at all. Paragraph 4 at 1430. It is clear that the application was made on behalf of Ms. Sadiqa under the Appendix EU family permit of the Immigration of the EUSS family permit. Common ground that she did not qualify under the scheme. And paragraph, if I can go forward please, to paragraph 28 on page 1436.
So did you say 28?
28 at the top, 1436. Applications refused by the ECO in a refusal letter recording that she had made an application for EUS family permit on the basis she was a family member. The letter stated she hadn't provided evidence, and at the bottom of that paragraph, therefore Ms. Sadiqa did not meet the eligibility requirements for the EUS family permit. Common ground already noted she didn't meet the eligibility requirements. Paragraph 75. The bottom of 1452. Although Ms. Sadiqa did make an application under the EUS family permit scheme, she did not make an application under the 2016 regulations for an EU family permit. This is for the detailed reasons given, and that's earlier in the judgment. The courts below assessed the application in accordance with domestic law and found the application was for an EUS family permit and not for facilitation under Article 3 of the CRD, to which effect was given by the 2016 regulations. The conclusion of the First Tier Tribunal and the Upper Tribunal on this point is, in my judgment, consistent with the approach of union law. This is because union law provides with domestic law to determine how to give effect to the rights to facilitation set out in Article 3.2, as long as the rights of facilitating effectiveness are not removed, answers the point which is not necessarily decided in Chelik. And then, importantly, because this really is the decision in Sadiqa and the significance of it, paragraphs 88 and 89, 1456 at the end. I agree that the effect of Ms. Sadiqa making the application under the family permit was more serious because the family permit route ceased to exist, but the withdrawal agreement was to give effect to the orderly departure, and then dropping a line, the withdrawal agreement carefully identified what rights extended family members would have in the run-up to the end of the transition period and what rights they would not have. I have not been able to identify a freestanding right to convert Ms. Sadiqa's application under the EUS family permit scheme into another application under the 2016 regulations and reject the submission that such a result is a triumph of form over substance. As it is, Ms. Sadiqa obtained entry to the UK through another means, and then it says what her rights are. Conclusion, for the detailed reasons set out above, the courts below were right to find she had not made an application under the 2016 regulations, and therefore any appeal under those regulations is bound to fail. And it then deals with Article 18. And so, in that case, it's clear that the applicant sought, the appellant sought to have her application under Appendix EU before the relevant date being regarded as an application for facilitation, even though it wasn't under the 2016 regulations. And the court held that it's not an application for facilitation under the withdrawal agreement. In our respectful submission, that is very different from the present case.
Thank you.
Unless I can assist my lords and the lady any further.
Thank you very much indeed. Yes, Mr. Delamere.
Can I start where I think we've got to analytically? National law, in principle, controls what is an application for the purposes of Article 3.2 CRD, or for that matter, Article 10.3 of the withdrawal agreement. National law can also be used to set the criteria for discretionary grant of facilitation of an extended family member and the criteria that can be used to review or appeal those decisions. And for that reason, references to national legislation in both the CRD and in the withdrawal agreements don't just encompass references to the single implementing provision, the Immigration EEA Regulations 2016. They also embrace the architecture of rules by which the status of those decisions is determined, set and adjudicated. So it includes the Senior Courts Act 1981, in particular Section 31, CPR 54, the common law rules given effect to those provisions, so our standard provisions of judicial review, etc. And importantly, in this context, given the debate we've had, the rule of interpretation, and I think the leading case on it is not in the bundle, the rule of interpretation in the case of Raisi, that says when you're construing an instrument like this, it's a question of objective interpretation, not what the decision maker thought they were doing. That was the exact debate in the case of Raisi. And that is why, in our submissions, from the get-go, we emphasised right up there with EU law principles, common law principles of fairness, and that's why we, in our intervention, drew attention to the fact that the case of Boddington showed that even if decisions like this were ultra vires, it didn't follow. They were entirely devoid of legal consequence in our domestic legal system. The points my Lord Justice Lewis has made in relation to the failure to effectively quash the decision and its enduring effect are merely an extension of the same principles. So that's the starting point. That is the primary role for national law in this context. Where there is common ground is that that national law role is not unbounded. EU law has a role in controlling how national law operates in that area. To put it another way, because the directive has created this topic of extended family membership, for which the definition of an extended family member is, if you look back at Bangor itself, a uniform concept of EU law. So who is an extended family member is not an area of management discretion. Because it's bounded by EU law, it's a debate within the scope of EU law. And that means, because it's within the scope of EU law, the Charter applies, because the Charter applies to any dispute in the scope of EU law. That's what Article 51 says. And Article 51 of the Charter does no more than codify the rules by which, before the Charter came into effect, the CJU determined when all of the EU general principles and all of the EU fundamental human rights rules applied. So proportionality, EU legitimate expectation, good administration, and fundamental human rights. And if you want confirmation of that, go back to the AT case. Lord Justice Green sets out Article 51, and he also sets out the explanatory memorandum to Article 51 that says it codifies cases my Lord Justice Lewis, I know, will be familiar with, like VATCHALF and ERT, which were accompanied by domestic cases like First City Trading, all of that stuff. So, once you're in scope, there is the control operated by EU law. And that's why you have to look at it from the plane of both domestic public law principles and controlling EU law general principles. Now, the only answer to that my learned friend gives is that she says the cases of Rahman and Bangor somehow excise the operation of EU law general principles. Now, with respect to my learned friend, although presented with customary clarity, that argument is utterly hopeless. It is hopeless for two reasons. Firstly, if you look at the Advocate General's opinion in the case of Banja, Bundle 2, tab 25, and you go to the Advocate General's opinion, the first thing you're going to note at page 884, paragraph 76, is at the hearing, the UK agreed with the Commission's submissions that EU law requires a full review of the decision, including consideration of the facts and proportionality.
But does it matter if the Commission, if the court didn't?
Well, we'll come on to that, because that's the context for what the court in fact said in its judgment. And what the court in fact said is in the context of the fourth question. What was the fourth question is relevant to understanding what they said. The fourth question was all about, effectively, whether JR, as opposed to a full merits appeal before the tribunal, was going to be compliant with the rights of appeal that were required in the circumstances. That's what you get from paragraph 42 and 43. But the critical problem my learned friend has is that in connection with that dispute, there wasn't any dispute about the application of the principle of proportionality at all. It wasn't a live issue. What is said is that the reason why you must carry over the Article 3.2 safeguards for family members by analogy to extended family members is because this is a context in which the Charter does apply. See paragraph 48. Since the provisions of the directive must be interpreted in a manner which complies with the requirements flowing from Article 47, that's the principle of effective remedial protection, C to that effect ZZ, those persons must have available to them an effective judicial remedy. That was the only principle that was in dispute in that case, because it was a dispute about whether or not the particular shape of remedy and court was adequate. What you can't do is infer from that that they are dispensing with the principle of proportionality or deliberately not referring to its explicit articulation in Article 31.3, not least because that would be incoherent. If the Charter applies, it can only be because we are within the scope of EU law, and once you're in the scope of EU law, as Lord Justice Green has explained, it's not just the Charter, it's all the general principles that apply.
I don't want to cut you off, but does it matter? Because aren't you only able to win really if the stamp means they were allowed in and could stay here? And then Miss Spy says, well, that's all right, that is a document then.
Well, that is the first route home, but I don't in any way abandon the second route home, which is to say that if it's not its effect as a matter of domestic law, there is nevertheless something that is in substance a request for facilitation, because that is ultimately a concept bounded by EU law. And that insistence, and it really does come down to insistence upon the correct forms being completed at the correct time, is ultimately a procedural requirement that is policed by a consideration of proportionality and good administration. And in asking whether or not it's lawful to apply that requirement to the facts of any particular case, the circumstance of the stamp is highly germane. That's our submission, and we've always presented it as a secondary case to the primary case my Lord's just identified, and we stick to that case because we do say there is a role for the principle of proportionality if the document doesn't amount to a document for the purpose.
If the document wasn't on interpretation meant to have legal consequences, or the legal consequences were limited to admission but not residence, how will proportionality get you more?
It doesn't get us more because our case has always been that what's required in those circumstances, go back to the issues of principle I formulated, is an opportunity, because of requirements of fairness and proportionate response, to perfect, that was the word I used this morning, to perfect the application. That doesn't mean presenting yourself again at the border or asking for a family permit when you're in the country. It means an opportunity to complete Form EEA EFM and have your case decided on its merits. That's what's required. That's what's been lost in this entire process, is any sensible response, which is to say, we can see you've been misled by the stamp in your passport. What you need to do is this. Please complete the form, and then we'll consider your case.
Right. So, if it doesn't give you the thing you need for a USF scheme permit, the reason why it doesn't do that is because you don't have an EEA family permit. And the reason why you don't have an EEA family permit is because they stamped you in rather than told you to go away. And if they stamped you in and told you, not rather than saying don't go away, then by some hook or by crook, proportionality requires an opportunity for that gap to be filled. Is that it?
That is it. What acme of good administration could there be more acme case than saying, if
we're much slower than you. I'm 96. I mean, I've just got to go a bit more slowly. So hang on, let me just write down what I just said. So, yeah. And that wouldn't, of course, help Mr. Vasa, though. That's why, yes, yes. Because he was given the chance.
Well, there may be a question as to whether or not it was an adequate chance, but I'm just picking what is, from my perspective, as I said yesterday, the best case. The test, the
so your alternative, if it's not an 8.1L4 thing, at the very least, it's not an 8L14 thing, to their fault. And they've got to have a chance, and then it's up to us to decide whether or not Mr. Vass's had the chance.
Yes.
Yeah.
And where I'm in agreement, I think, with my learned friend, is that the principle of proportionality doesn't come in at the Article 18 stage. It comes in at the Article 10.2, 10.3 stage. And it comes in because proportionality is required in an Article 3.2 decision, once you understand Banger properly. So we're not trying to use the withdrawal agreement, as she accused us of, to improve the content of the Article 3.2.
So what are you using proportionality for? Are you using it to interpret words in Article 10.3, or are you saying we're still able to rely on Article 51 of the Charter? Or
what's using it to interpret the notion of what is an application of facilitation in Article 10.3 to say, notwithstanding its procedural defects, notwithstanding its non-compliance with Regulation 21, it is nevertheless treated by EU law as being in substance an application for facilitation. That's what I'm saying. And it goes back to the debate we had in Chelik about what would happen if you forgot to sign the document, or you left one box empty such that it was substantially or necessarily invalid under Regulation 21.4. And we would say those types of faults, which could proportionately be met with the answer, go away and start again before the cliff edge, no longer can be met with that answer once there is such a cliff edge effect.
You do then have the Siddiqa problem. If that is how you put it, that is exactly what Mr. Metz has just shown us. Paragraph 88 decided that you cannot use proportionality according to the Court of Appeal to substitute one application form, the USSS, as if it were another one.
We're not doing that.
We're not doing that.
In Siddiqa, a full-blown application was completed and made. The question of fact was whether the application that had been made was an EUSS application or an EEA application.
So what application has been made that we have to interpret proportionally?
An EEA application has been made
by tending the
border, as evidenced by the stamp, because the stamp says pursuant to the EEA regulations, and we know judicial notice, Preston, Prestadell, inference, say what you like, that they must have been asked questions at the border about their extended family relationship.
So it's completing that application, not substituting a different one.
Exactly. Yeah. That's the point. It's that application made informally at the border is kept alive, and you are given an opportunity to cure its procedural defects. And it's in that connection that we say not only is Banger properly construed in our favour, because it's necessarily predicated on all these issues being in scope of EU law and in scope of EU general principles, Article 9.3 necessarily applies by analogy, and it says in terms, don't apply disproportionate sanctions for failure to convert into a residence card. And you have my submission that applies by analogy, just as everything else does. And indeed, the point is somewhat stronger than that, because if you go to the linked provision, Article 10, with which Article 9 has to be read, and you look at Article 10.2e, page 103 of the bundle, you will see that that is explicitly about extended family members, because it refers to cases under Article 3.2b of the directive. That's the exact scenario. 3.2a of the directive is the exact scenario. So that's what we say in relation to that. A very brief word on Petraea and Macastena, and then one other thing, and then I'll sit down.
Well, you've got very little time. I didn't say 4:40. I said 4:30. And we might squeeze a little bit longer. We've literally got to leave the room at 4:40.
Hopefully I'll be done by 4:33.
Okay.
Petraea, the very short answer to that is, if you read, again, the Advocate General's opinion, paragraph 6, you will see the provision of Greek law pursuant to which the certificate in question was issued. The provision in question effectively provided for the Greek authority to declare or set out publicly the EU law rights that were in play. It wasn't a case where in any way the scheme in question was creating or constituting rights. And that's because the only place that happens is in an Article 3.2 case. By contrast, the IEA regulations are a mixture of both. They're a mixture of reflection of the directly effective rights and the procedures by which constitutive rights under Article 3.2 are granted. Once you're into the terrain of constitutive rights, as you are in Article 3.2, and for that matter you are when you get into Article 18 of the withdrawal agreement, the logic of Petraea ceases to apply. It only applies to pieces of paper that say, for instance, you are exercising your treaty rights by working, or something of that kind. So that's Petraea. It's a distraction. Macastena, the simple answer to that is that my learned friend's submissions in relation to that case were a non sequitur. She said, effectively, that because the mere notification to the Secretary of State of the fact that you're in a family relationship doesn't amount to an adjudication of that case by reference to its factual circumstances, led to the inference, she said it flowed from that necessarily no application for consideration has been made. And that just doesn't follow as a matter of basic logic. So that's the short answer to that. And then the last point, 2 minutes early, my learned friends, my Lord, Justice Underhill, said, well, if we go to Luxembourg, but that would be impossible. I'm afraid it's not impossible.
Of course, yes.
This is a case in which Article 158 of the Withdrawal Agreement, Bundle 1, tab 69, does operate. Unlike the case of Harrington, which I did before my Lord Justice Davies, the facts here raise a question of interpretation of the withdrawal agreement, and one option is to refer. And you won't be surprised, make the usual submission in those circumstances. We're obviously right, but if you think or have any doubt as to whether or not we are right, then important questions as to the interpretation of Article 10.2 and 10.3 arise, and there are questions that are liable to affect a sizable cohort, we don't know how large, of people in this country, and equally, they're liable to affect UK citizens affected by similar types of errors elsewhere in the EU. And therefore, you have a discretion, which I simply advert to, as to whether or not to refer in circumstances. Unless I can help any further, I've finished it.
No, I think there's one point we want to just have a word about. You come round, as this time is short.
Is it a question for me, my Lord, or should I say?
No, it's not. On the point about reference, were we to be considering a reference, we would invite submissions, but we won't do so now. Well, we are most grateful to the extensive legal teams for the extensive legal argument which they have generated. I think it's perhaps also just important to say that although the legal issues are very dense and arcane, we haven't lost sight of the fact that there is a real human situation behind this and real people who are very concerned about their rights to remain in this country, and that's just worth saying explicitly. We will be reserving our judgments in the usual way. They will be sent to council in draft. There are rules which I needn't remind you of, but I need to remind you of in detail about the limited purposes for which those documents are circulated. So if they are passed, as they will no doubt have to be, to people other than council, it should only be for the limited purposes identified in the Consul General for Wales case, and if they are used for any other purpose, that may well be a contempt of court. Then I think there is nothing more that I need to say. We've got one loose end, which is a copy of the guidance. I won't insist on being given copies of all the other cases that we know about. If it's a very easy matter and you have them, why not? But I don't want to put, after all the work that has been done behind you in particular, Mr. Spy, I don't want people to spend hours trying to dig out other cases of this kind. But if they are available, it's helpful just to know what they are and have them.
Why not? Yes, we'll certainly give as much as we can. Within what time frame? Because that will affect how much information we can pass on. Is the court thinking by close tomorrow or close Monday?
Well, I think it's not as extremely urgent as it sometimes is. Sometime next week would be enough. Thank you.
I can get on with it.
Yes, thank you. Thank you very much. Thank you, everybody.